If you run a company that sells products in the United States or that has employees there or that has contracts with American counterparties, you are exposed to one of the most complex and expensive litigation systems in the world. Probably no one has explained this to you, and you don't know exactly what that exposure means. That's what this series is about. And my guest, Kent Schmidt, is a US litigation attorney who has spent decades advising companies, including foreign ones, navigating commercial disputes in the US. Kent and I will walk you through the features of the US legal system that make it so different from anything you'll find in Europe or in other countries, and so much more dangerous for foreign companies who are not prepared. This series is based on the book Avoiding and Managing U.S. Litigation Risks, authored by Kent Schmidt, now also available in Italian and French editions. Kent, welcome.
Well, thank you very much, Roberto. We've had so many conversations over the last few years on this topic, usually over good food and wine as well. But absent the food and wine, it's great to have a conversation by video and revisit we've discussed and perhaps a few new ones along the way.
Totally agree. So, Kent, let's start with the basic premise. You wrote a book on the risks of U.S. litigation, and I had the pleasure to help you draft the Italian edition. And that because we believe that foreign companies operating in the U.S. are not really prepared for the litigation risks they are taking on. Is that a fair characterization?
Well, it is, and I've experienced these conversations over the years, both with domestic and foreign companies, that the first they're aware of a vulnerability is after a lawsuit or a demand letter from a class action lawyer has arrived in their inbox. And at that point in time, it's often too late to do anything prophylactic or preventative. The claim is already asserted, and so we have to extinguish the claim, resolve it. Often that is very expensive. It can be litigation or even an early settlement, but one way or the other, it's a significant outlay of cash and a huge distraction for the company. It's not what they are supposed to be spending their day thinking about and spending money on. And so it catches companies by surprise. And the premise of my book and a lot of speaking I do is that so much of this is preventable if you have a little more insight into where these claims are coming from, the trends, and sometimes the steps to take are so easy. The metaphor I often draw upon is it's like someone standing on a trap door and they don't realize that they're standing on a trap door. Perhaps it's covered in a rug. And all they have to do is step to the side. So sometimes that's not the case. Sometimes the prophylactic or preventive measure requires a lot of work and is going to actually impede the company's business to some extent or another. You have to make a cost-benefit analysis. But often the steps to take can be very easily implemented. It's just being aware of the issue in the first place.
Yeah, right. In your experience, at what point does a European company typically first call you?
Well, I think even more than domestic companies, European companies are often caught flat-footed, and understandably so. Their focus is on EU compliance and other regulatory compliance issues. Even though class actions exist in Europe and civil commercial litigation exists, it's not on the scale of US. And so their focus is often, appropriately so, on compliance with applicable regulations, avoiding some sort of enforcement action or administrative fee that could be costly. And so they're often, when they enter the US market, or even if they've very established in the US market, they're less aware of the potential liabilities, and they think this isn't right. This is just a private plaintiff that is asserting these claims, and so it takes a little bit of I guess resetting to understand the landscape in the U.S.
Right. So before we get into the specific features of US litigation, I want to make sure our listeners understand the fundamental structural difference. So Italy, like most continental Europe countries, is a civil law system. The US is common law. And this for an entrepreneur probably means very little. So can you explain concretely what that difference means? And when you are sitting across from an American adversary in a dispute, what it means in practice?
Sure. So, as you mentioned, we in the U.S. have inherited much of our legal system from the legacy of the common law system in Europe, which a simple bottom line explanation for that is that the law is driven in large part by decisions that judges make, mainly appellate judges, but also particularly in federal court, district court judges, trial court judges, in deciding motions and other matters that come before them. And those decisions are what we call precedential authority. They determine the future of the law, and they are looked to by judges that are applying the law to current disputes before them. Of course, we have statutes, and there's an exception, which is Louisiana, which is a civil law jurisdiction. It is based on the Napoleonic Code. So, but that's the one exception out of the U.S. Of the 49 other states are common law driven systems. And so that means that in a typical situation, the legislature will enact a statute that may apply to a dispute, and the courts will look to what the legislature intended. They'll look to the plain wording of the statute, but they'll also look with as much, give as much weight to how courts have interpreted that statute over the last several years in particular. And so this body of law continues to grow. And when we are litigating issues, we are talking about the importance of precedent as much as we're talking about the text of a statute.
I see. So say that when an Italian company signs a contract with a New York counterparty with a New York governing law clause, they're not just agreeing to a different set of rules, but rather they are agreeing to a fundamentally different system of reasoning about what those rules mean, right?
Yeah, that's correct. And that evolves. The statute that may be applicable to that dispute may have not changed in years, but the decisional authority comes out with great frequency. I was litigating a case just yesterday, and the other side cited a case that was just decided in March, which is new law here in California. Hadn't been decided before, and it significantly impacts our dispute. And so now I've got to go back and see what three appellate judges said just a few months ago. That's a challenge in U.S. because there's so much case law out there. And of course, we use various tools to do searches and now AI to drive our research and try to find decisional authority out there. But it is a significant adjustment for European litigants to understand how U.S. case law works.
Yeah, and I would say that this is even more important if you consider that the applicable law, at least as far as many cases I've seen in my career, is decided upon during the negotiations at the very end as an afterthought. So you decide, well, let's apply New York law rather than, I don't know, Texas law or California law, but that has a significant impact on the merits of the contract.
It certainly does, because there are significant differences between U.S. jurisdictions, even though we're all based on the common law. Without delving too much into political issues, I think most Europeans understand what I mean when I said red state, blue state.
Yeah,
We're a very divided nation, and therefore, how a judge in Texas interprets a particular dispute and applies the law of Texas to dispute even common law can be quite different than in New York or California. And that's true even in outside of the, major social issues that divide us. That's true in a variety of different commercial litigation contexts as well.
I see. Kent, the book starts with a brief history of how the US became so litigious. And it's not an accident, it's the product of a specific legal and cultural choices made over 200 years. Can you give us the condensed version?
Well, again, I guess we have already crossed the line and we talked, I've touched on politics. So um, I guess we'll touch on economics as well. Well, the US is, as you know, a very capitalist, opportunistic culture and system. And it's important to view various permutations and applications of that concept through that lens. So, for example, there is not the type of shock and dismay at lawyers um, earning a significant return on their investment in contingency fee cases, where a lawyer will have a 30 to 40% share of the return of any award that is given or any settlement that is given. So the legal profession is a regulated profession, but it is regulated within the context of allowing individuals to, make as much as they can possibly make within certain very limited bounds, pursuing their opportunities. And litigation is viewed as one of those opportunities. And so there's, in other jurisdictions in Europe, the idea of a contingency fee arrangement is viewed as very suspect if it's allowed at all, not in the U.S. And so the bottom line is that our system, which has become very litigious, is driven by how we view the legal profession and how we view the drive and the free market of lawyers, the drive of lawyers in a free market to pursue opportunities. Um, that's that's how I would summarize our where we are today with a very litigious system.
Yeah, so we can say that it's not just a system, but rather an industry with um, lawyers being economic players who have an interest in even generating litigation.
Yeah, I think it's important, particularly in the class action space, but other litigation as well, to view lawyers as very similar to, private equity, that says,
Mhm.
here's an opportunity, this is what we're going to invest in it, and this is going to be the return. And some have um, done very, very well in that arena, and that's a system that seems to work. And it's defended by many in the U.S. as um, you know, while someone's going to make an enormous amount of money pursuing lawsuits against companies for their labeling of their food, or lawsuits against companies for how they treat and pay employees, or shareholder litigation. Those are the major areas of plaintiff work in addition to personal injury. The defense of this system is, if you set aside how much money the lawyers are making, the benefit is that with very little taxpayer dollars and very little regulatory oversight and outlay, uh, what society is getting is safer products, fairer treatment of employees, um, more robust disclosure to shareholders, safer premises that is designed to prevent personal injuries, and so that there's a societal benefit, and you shouldn't get hung up on the fact that someone is making an enormous amount of money from pursuing this, any more than this debate right now as to how much SpaceX is worth and how much Elon Musk is making. So that I see that debate and that back and forth as to the cost benefits of capitalism as being borne out and exemplified in a discussion, and I think a very legitimate debate about the pros and cons of our litigious system.
Yeah, right. Um, Kent, in the book and in this series, we identify 6 features of the US legal system that make it uniquely dangerous for foreign companies. So let's give our listeners a map of what they are before we go deep on them in the next episodes. Can you run through them briefly?
Okay. Well, I've already mentioned the first, and I think it
Yep.
is the most significant, the
Yep.
contingency fee arrangement, which it is not just in the personal injury space, but is in shareholder litigation, employment litigation, and consumer protection litigation. That often is multiplied significantly when there's class action litigation. But even in single claim cases or single plaintiff cases, the contingency fee arrangement is significant. In addition, we have jury trials in the U.S. This is, again, not to get too historical and philosophical about it, but this is there are jury trials in England, but much more limited. And in the US, we cross this threshold into jury trials in almost any civil matter. There's a distinction between law and equity, which I won't get into. You don't have a right to a jury trial on claims that are in equity, but only in law. But in contract disputes and all types of commercial litigation, a civil litigant has a right to a jury trial. And the net effect of all of that is that juries end up deciding multi-million dollar verdicts, cases, and issuing and rendering verdicts in incredibly complicated um, uh, business transactions, complicated matters involving trade secrets and technology, things that are very, very difficult to grasp and understand, can be decided by civil juries. And sometimes we have what we call nuclear verdicts, or runaway juries that can, hear the right case and be gripped by it, and at least figuratively ask, how many zeros can I put at the end of that number? And so that's a very significant area. One, and that leads to the third, and that's punitive damages. Juries are entitled to decide um, not just liability, but damages, and further to determine punitive damages. So punitive damages, the name suggests, are not intended to just make the plaintiff whole, but to punish the wrongdoer, to set an example not just for that defendant, but to set an example for anyone else in the industry, that this is what happens when your premises aren't safe and you have someone that's injured or the like. And so that's uh, can be a huge cultural shock for European companies when they are assessing their liability in connection with litigation. The fourth is the rule on attorney fees. And the American rule on attorney fees, again, unlike the British, we described some of the commonalities between the US and England, but there are a lot of divergence. And the attorney fee, what we call cost shifting, is one of those. The general rule in the US is absent a specific statute or contract provision, a plaintiff that is unsuccessful in bringing their claim does not have to pay the prevailing defendant's attorney fees. Um, that is often that situation is often changed in a contract where the parties expressly provide for prevailing party attorney fees and for it to be bilateral. And it's also the case in certain statutes, but in many of the statutes, it's a one-way street. So only the plaintiff that is successful can prevail in getting their attorney fees. The successful defendant who defeats a claim is not successful, it cannot obtain attorney fees. And so that tips the scales and creates greater risk for the defendant who is facing, for example, a consumer class action, because they're going to be liable not just for the damages, for their own cost in defending, and perhaps punitive damages. They could very well be liable for the attorney fees that the plaintiff would recover in the event that they prevail. And that drives the settlement demand as well. The fifth major distinction doesn't have so much to do with the end result and the exposure, but the process. And I'm, of course, referring to our invasive discovery procedures, which are quite a surprise for most European companies. Discovery in U.S. litigation makes up a huge percentage of the overall litigation budget. It is a very significant burden. It's been for many, many decades, but with the advent of email and modern technology and all sorts of ways of communicating, and now even AI communications, there's there's the information explosion, which data is everywhere. And so litigants can spend a lot of time going and collecting that data, which can be incredibly insightful. Emails written years ago that come to the surface in litigation can change the outcome of litigation. And that extends also to depositions, which are unheard of. We take a lot of depositions. I think the most depositions I've ever taken, or my team has taken in a case, is over 50 in one case. And so we just went for days and days of depositions of their witnesses and our witnesses. That's a little unusual, but in a typical commercial litigation case, 3 to 4 depositions per side is not at all unusual. And that's a 7-hour ordeal where you're sitting in a conference room being asked questions while your video is being recorded and a court reporter is taking a transcript. And that's a very intimidating process. It's also a very costly process. And so the discovery rules are very, very significant. And then I touched on this, but it bears repeating: class actions. Class actions are now in dozens of jurisdictions around the world, but they're not quite the same in those jurisdictions as they are in the U.S. They're much more common and much more lethal when they are brought. And then they also class action system encourages the pre-lawsuit demand. if we don't settle, I'm going to bring a class action in the next 30 days. So I spent a lot of time assisting clients in settling pre-lawsuit class action demand letters.
Oh, yeah. Kent, I want to end this first episode with a mindset question. We're not trying to scare people away from the US market. It is, after all, the largest single economy in the world. What is the right way to think about litigation risk in the US? Not as a reason to stay out, but as a factor to manage.
Well, it's I have to harken back to a saying of one of our founding fathers that I invoke all the time, Benjamin Franklin, who spent a lot of time in Europe at the founding of, or at the beginning of the founding of our nation, trying to garner support from France. Um, Benjamin Franklin said, "An ounce of prevention is worth a pound of cure," and I think in almost any culture there's some equivalent saying of that axiom. Um, it's so much easier to uh, take steps and think about the litigation risk on the front end than to try to extinguish these fires after they've started. But that takes a lot of thought and insight. There's not a one size fits all. Every business plan, every um, plan that's going to involve entering the US market is going to involve different risks. Um, the risks are going to vary from whether you're business to business or you're selling to consumers, how your products or services are being distributed, whether you're regulated or unregulated, um, the industry, where in the U.S. you're going to be marketing. California is the most litigious. It's the largest market, but also the most litigious of all the 50 states. So I view California, which is where I practice, as sort of the high watermark of litigation exposure. It's not it's not accurate to say if you comply with California law, then you'll comply with the other 49 states. But usually, if you're in compliance with the standards in California, the others are easy enough to address. But that's actually an important point as well. You're not just addressing federal law, but you're addressing sometimes a patchwork of 50 different approaches to because we have 50 different states, and you can be sued under state law as well. And so getting a handle on all of this and thinking about, quite simply stated, if I'm sued in connection with this expansion into US markets, what's the most likely source of that litigation, or the sources? And what are the steps that we can take? Anything ranging from a forum selection clause provision to, um, uh, compliance with US standards for products and services, and a whole variety of other prophylactic measures. Uh, Definitely time and money well spent.
Okay. So that's exactly the frame for this series. We're not here to say don't go to America. We're here to say if you go, go with your eyes open. Uh, Kent, one last thing. If there's one sentence you'd want a European CEO to remember after this first episode, what is it?
If you're entering the US market with your products or services, you should recognize the significant changes in the litigation and commercial lawsuit exposure that you're facing, and take important steps to reduce the risk of those lawsuits in the future.
Right. Kent, thank you. In the next episode, we're going to start unpacking those 6 features. And we're beginning with the one that probably funds the whole system, the contingency fee and the litigation funders who have turned commercial lawsuits into an asset class. Thanks a lot, Kent, for joining, and I'll see you very soon for the next episode.
Thank you very much. It's my pleasure. Take care.
Bye bye.